What does beyond a reasonable doubt actually mean? If you've ever watched a criminal trial on TV, you've heard the phrase proof beyond a reasonable doubt. But what does that actually mean? Does it mean 90% certainty, 95%, 99%? The answer surprises most people. Here in Arizona, jurors are actually given a written instruction explaining what proof beyond a reasonable doubt means. It's called the Portillo instruction. Part of it says this: proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. Then it continues: there are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every doubt. And then comes the sentence that I think is the most important. If, on the other hand, you think there is a real possibility that the defendant is not guilty, you must give the defendant the benefit of the doubt and find them not guilty. Notice what's missing. There isn't a formula, there isn't a percentage, and there isn't a checklist. The law intentionally doesn't define exactly how much evidence is enough. Instead, it asks usually 12 ordinary people to decide whether they are firmly convinced or whether there is still a real possibility that the defendant is not guilty. That's why I tell juries something the prosecutor usually doesn't like hearing. You are the ones who decide what is reasonable. If you genuinely have a doubt, no lawyer, no prosecutor, and frankly, no judge gets to tell you that your doubt isn't reasonable. The prosecutor will often argue that some doubts are unreasonable. The defense argues something a little different. The defense argues that if an honest, thoughtful juror still has a real possibility in their mind that the defendant is innocent, then the law requires a not guilty verdict. And over the years, I've seen juries reach that conclusion for very different reasons. Sometimes it's because there simply isn't enough evidence. I've had cases where the prosecution presented evidence that made my client look suspicious. Maybe there were text messages, maybe there were circumstances that looked bad, but when you slowed down and actually examined the evidence, there were still gaps. There were still innocent explanations that fit the facts. I've used the analogy that proof beyond a reasonable doubt is like a net. If the government's evidence really proves guilt beyond a reasonable doubt, there shouldn't be any avenues of escape. There shouldn't be obvious holes where innocence can still fit through. If there are gaps that leave open a real possibility that the defendant is innocent, then the burden has not been met. I've also seen juries acquit because the evidence itself wasn't reliable. One case that stands out involved a DUI crash. My client admitted that he had been drinking, and that wasn't really the issue. The issue was whether he had committed aggravated assault, whether he had caused the accident. An officer told the jury that my client failed to yield while making a left turn. But we showed the jury photographs of the intersection. It was one of those unusual intersections where you either have a green arrow, meaning that you have the right of way, or you have a red light, meaning you're not supposed to be moving, you're supposed to be stopped. In that lane, there's never a point where you're required to yield. Even more interesting, the officer's own body camera captured him saying that he was going to inspect the intersection before deciding what happened. He came back claiming that my client failed to yield, but that explanation simply didn't match reality. So the jury had to ask itself a simple question: did the officer actually investigate? Or was he saying something that wasn't true? Once the jury stopped trusting that testimony, reasonable doubt naturally followed. I've also had juries acquit because they disapproved of the investigation itself. I've had detectives admit that they never visited the scene. They never collected evidence that they could have collected. Then, instead of admitting that mistake, they tried to explain why they wouldn't have found anything anyway, which is backwards. You don't get credit for guessing what an investigation would have shown if you never bothered to conduct it. Juries understand that. I've seen juries essentially say, no, that's not how we expect criminal investigations to be conducted in our community, and they return not guilty verdicts. The common thread in all of these cases is this: reasonable doubt isn't just about counting pieces of evidence, it's about whether you trust the government's proof. Is it complete? Is it reliable? Was the investigation done fairly? Has the government really eliminated the reasonable possibility of innocence? Those are questions every jury has to answer, and they're questions that every defense attorney should be asking. Because despite what many people think, a criminal trial isn't supposed to be a rubber stamp. It's supposed to be a test. The government has enormous power. It can investigate you, charge you, bring you to trial. But before it can take away your liberty, it has to convince 12 citizens beyond a reasonable doubt of your guilt. Not beyond suspicion, not beyond probability, beyond a reasonable doubt. That's one of the most important protections that we have. And it only works when jurors take that responsibility seriously and when defense attorneys are willing to challenge every assumption the government asks the jury to accept. I'm Joel Chorny. Remember, you have rights. They matter. Protect them. Stay safe. And I'll see you in the next video.